And for the record, my name is Sean Hoover. I have recently joined, or I am the attorney for Ms. Patrick moving forward. Latoya Williams was the attorney. She no longer works with the Public Defender's Office, so I will be moving forward here on.
Now, now that you paused and said recently, you overtook this case in February.
February, that's correct. For me, it's recent. I apologize. There's been a number of trials since been in now. So I've been on the case since February, Your Honor, and we're asking for a continuance today regarding Ms. Patrick's case. I know the court has already read the case law involved. Just to put a couple of highlights on the record. For starters, Your Honor, once I took over the case, I put an entirely new team on Ms. Patrick's case. With that said, I got the case, there was a lot of discovery involved, started to go through the discovery while I was trying other cases. Once I realized there were certain issues that hadn't been addressed when Ms. Williams represented Ms. Patrick, I started to create a team or bring a team in that could address those particular issues. At the beginning, I thought it was just a chain of custody issue, and it turned into a lot more than that. To give you an idea or a little more of an understanding, I brought in Mary Dayton, who is an attorney with the Public Defender Office. I worked with her when I was with the Capitol Office. She does a lot, has done a lot with juvenile clients, especially juvenile clients dealing with capital cases and dealing with forensics. What I thought was just a chain of custody issue turned out to be a much larger issue dealing with GBI, the Sheriff's Office, Police Department, and just evidence in general. With that said, we brought in also a mitigation investigator, Olivia, who's at the table with us as well, who also deals with capital cases, also deals with juvenile cases, but also deals with the mitigation aspect of it. Once Ms. Dayton and Olivia came in, we found out that based off of current case law, not only with the United States, but also in Georgia, certain issues weren't addressed when Ms. Williams had the case and Ms. Williams announced ready. Mainly because of the age of Ms. Patrick when the shootings actually occurred. Because Ms. Patrick was a juvenile at the time, case law is a little different when it comes to, for one example, sentencing in regards to how and when a juvenile can be sentenced to life without possibility of parole, death penalty, or life with possibility of parole. Because of those issues, I believe it was about 2 weeks ago, I believe Olivia just said that we got the defects information around June 30th, which literally wasn't that long ago. Yes, Ms. Williams had an expert that, to be nice, did some work on the case, but the expert didn't have Ms. Patrick's, and the expert I'm talking about, Dr. Schaefer, didn't have Ms. Patrick's defects records when he did his evaluation, when he spoke to Ms. Patrick and family members, when he came to his ultimate conclusion. Now that we have the defects records, that has opened up, for lack of a better term, a whole other can of worms in regards to not only sentencing because of Ms. Patrick's age, but also our theory moving forward, especially crossing certain officers and certain witnesses based off of the evidence that we did receive from the state. So with that said, we're asking for a continuance for multiple reasons. The first one will be because now that we actually have a team in place that can actually address the issues facing Ms. Patrick because of her age at the time of the shooting and because of all of the background history that Ms. Williams, she just didn't know about because she didn't have it. Literally, we sent you the order and you got the information as quickly as possible. But we're talking about over 10 years worth of information that now we have to go through not only for sentencing, but to combat certain things that I believe witnesses and especially officers are going to say on the stand in regards to their investigation. So we're asking for a continuance for that reason because we just need more time to go through all of that. Again, the case law, like I know the court's aware of the case law. The case law, not specifically, the case law points towards it's a sentencing issue, which it is, and we need more time for that. However, without going into more detail, there were certain statements made and certain reports that were written from the lead investigator and other officers, which tells me now that those defects records, the mitigation aspect of this case that we thought was something that we had, that wasn't as important during the trial, well, now it is, because based off of what we've read and based off of what we received, it will be an issue in this case, especially with the lead investigator. So the first point we're asking for a continuance is because we now have the team put in place to address the issues specifically based on the mitigation aspect of this case, which was not addressed before. Dr. Schaefer had an evaluation that the state has and the court has that he did not have the information that we have, and based off of that information, more needs to be done so that I can adequately protect Ms. Patrick's interests moving forward. Furthermore, we're asking for a continuance, Your Honor, based off of evidence that we believe is still outstanding. And when I say that, again, when Ms. Williams had the case, the state of Ms. Williams announced ready for trial. And I understand, based off of the information that the parties had at that time, they believed they were ready. However, once I took over the case again, I thought this was just a chain of custody issue, and it turned into something a lot bigger. And to give the court an idea without going into too much detail about our theory, since I've taken over the case, I've actually been able to delve or dive deep into it. There are issues with what officers did in this case. There are issues with the Georgia Bureau of Investigations in this case, and we have started to get more information, more evidence from the Georgia Bureau of Investigations and from law enforcement. With that said, the state and I met on Friday in person to go over the physical evidence in the case, and we talked about that as well, and the state is helping us get more information. And to be clear, this is not an issue that, like, the DA was hiding information. This was more of, I saw an issue that I believe Ms. Williams just didn't see, and it snowballed into something a lot bigger than just a chain of custody issue. So now we are still trying to get information from Georgia Bureau of Investigations to fully understand the forensics in this case, to fully understand the chain of custody issue in this case, to fully understand the procedures in this case. And we are literally still requesting information from GBI that's still coming in. And now we've actually asked the DA to help us out on that because this is information they need as well. So this isn't something that's like, well, aha, we knew about this earlier. This literally, again, started out as a chain of custody issue, and it has snowballed into something bigger to where we're going, and this deals with possible 702 Daubert issues moving forward. We're literally dealing with forensic evidence. We're literally dealing with chain of custody issues, proper procedure issues, not only through local law enforcement, but through the Georgia Bureau of Investigation. So we're asking for a continuance on that as well because there's still information coming in. And finally, Your Honor, and again, this is not me saying the state withheld anything, because I honestly believe the state didn't know about this as well. But on Friday, when I met with the state to go over the physical evidence, they sent a supplemental report from an officer with local law enforcement. The issue is this officer is in other reports. This officer is on the witness list. But from the information we received, the information Ms. Williams had, this officer literally didn't really do anything in the reports. He was just there. Now we find out that this officer did not write a report. However, he went to the DA's office literally last week and said, you know what? Well, and I'm sure they can correct me if I'm wrong. My understanding, this officer had a hunch that the gun that was possibly used for the shooting was pawned by a certain person we never knew the name of from the discovery sent over by the DA. And that officer's hunch turned into, it went to another person that had the gun, and the officer tested the gun and then gave it back to the other person. We had no idea these two people existed. We had no idea this test existed. We had no idea there was a possible another gun. We We had no idea there was a possible hunch. We have no idea how the officer came to that conclusion. And again, Ms. Williams of the state announced ready for trial for January. The state didn't know about this. We are now in a position to where I honestly don't know, was this one rogue officer that just did literally whatever he wanted to and never reported to anyone else? Or is there more involved in this? I need to now follow up on the hunches. I need to now follow up on how he even got to this conclusion. I need to now follow up on the two people, well, it is more than two people at this point that I didn't know about until Friday, literally Friday afternoon, that I need to now follow up on them. I need to go to the pawn shop to see what happened there. I mean, there's so much more information that we have uncovered since I've taken over the case and I brought my team on, that we can't fully be prepared to go forward with defending Ms. Patrick. As of right now, and again, this is not the DA's office that held any of this information. This was now I see there's a problem. I thought it was a small problem. It has snowballed into a huge problem. And as of Friday, now we know that there are officers that really didn't do anything or didn't provide anything in evidence that was presented to or turned over to Ms. Williams and then turned over to me, that now they're coming out the woodworks that there are possible other guns, possible other suspects, possible other contacts, possible other connections that no one knew about up until now. And again, the case law, the court has already read the case law, so I'm not going to delve into that, but we are in the position now that I understand this trial was set, or this case was set to go to trial. And I understand that Ms. Patrick has been in jail this entire time. She and I have had this difficult conversation, but I'm in the position, due to her age, due to the circumstances surrounding the case, and due to the mitigation aspect, the new information aspect, the possible other weapons, other people. I mean, there's so much that has been uncovered within the last few months that we have delved into this case that we are asking for more time so we can be prepared. And not only for sentencing, but for the case in chief itself. The mitigation aspect of what we are looking into not only goes to sentencing, again, it goes to actual issues with investigations that these officers conducted, especially the lead investigator in this case. So the mitigation issue deals with her age, sentencing, and the case in chief, but now we know GBI evidence, that there's still more coming in, still more information coming in, forensic evidence, there's still more coming in. We will be having 702 Daubert hearings, we have to, on specific information and what will be admitted, what won't be admitted, who will be an expert. There's a chain of custody issue, and again, now there's new evidence that there's some rogue cop that now literally didn't write a report at the beginning, but apparently a couple years later, a couple weeks before trial, he remembered, now I need to write a report, and there's a new gun we need to talk about, there's new, again, forensic evidence we need to talk about, there's new contact information we need to talk about, and this is not from the state, this is information that we uncovered because I saw there was a problem, and the problem turned out to be a lot larger than what it was. With all of that said, Your Honor, due to the nature of the crime, due to the fact that Ms. Patrick is potentially looking at, 2 life sentences without possibility of parole, as a defense attorney, I need more time to uncover or to just delve deeper into all of this new information that we've uncovered before I can properly say that I can represent her zealously and cover all my bases. This is an issue that I don't want to come back 20, 30 years from now and have to relitigate all of this because another officer popped up with new information that we didn't know about before. Like, this is not I'm grasping at straws. There's an actual issue here that the state and I need to uncover before we can properly move forward with this case. So for those reasons, Your Honor, unless the court has any questions, we are asking for a continuance so that my team that we've put together that is suitable to handle all this information can actually do just that. We just need more time because there hasn't been enough time yet.
Thank you.
Thank you.
State, do you have a response?
Thank you, Judge.
State, you'll approach and give your response.
Thank you. I do want to touch on a couple of things. First, in basically the order that defense counsel went through them. He said that there is a new team that they put together specifically for the mitigation or issue, specifically regarding the defects documentation. We'll break that down a little bit. First, they put their new team together and they want to change their expert, but they're only doing this in June. February, they didn't ask for this. March, they didn't ask for this. April, they didn't ask for this. May, they didn't ask for this. And well into June, they didn't ask for this. Here we are on the eve of trial, and they're not asking to change their expert. If they wanted to do so, they could have done so then. Prior counsel on the case, Ms. Williams, when she got the case, she hired Dr. Schaefer very quickly after getting the case, and they still didn't get a report for 6 months. Not through defense counsel's lack of effort in getting that, it was just Dr. Schaefer didn't turn it over. I can understand why they want to change their expert. If they want to do so, they've had 6 months to do it. They still have, from my count, 21 days. We are 3 weeks from jury selection. We're still well within the 10-day limit for the state. They can go ahead and do that sort of thing. As far as the DFACS records that we brought up, we got those DFACS records a handful of weeks ago. They are largely duplicates of what was already turned over. The significant portion of those documents relating to the defendant and her history were already turned over, already examined by Dr. Schaefer, already examined by the state's expert that we hired back in February for this. That is something that they could have done. They simply chose not to.
So the state's position is that the vast majority of the DFACS records that were turned over, let me say, about 3 weeks ago, are duplicates that have already been available to everyone.
Yes, either the documents themselves or the information contained therein. They are information that was out there long in advance, things going back to the history of the defendant in relation to her interactions with DFACS.